everyone, and thank you so much for joining us for today's webinar. Today, we're going to be talking about how to obtain a green card based on employment, and we'll be talking about a few options in that context. We're very fortunate to be joined today by our firm's partner, Kelly Legrand-Wiener, who has extensive experience helping clients navigate this process. Our firm is primarily a business immigration firm, but we do handle the full spectrum of immigration law here in the U.S., whether that's family immigration, humanitarian immigration, and as I mentioned, employment-based green card options. Now, what we'll be covering in today's presentation is actually quite a common topic because many of our clients are in the U.S. on non-immigrant visas, such as TN visas or E2 visas, which are focused on work or investment. And so the pathway to get a green card from those non-immigrant visas is of course a topic that's on many people's minds. So Kelly will be going into greater detail in this presentation on that topic. A few housekeeping items before we get started. We try to do at least 2 webinars a month, and I think at this point we're probably doing 2 a week. So those webinars do run the full gamut of topics in U.S. immigration. We do try to record our webinars. So after this presentation, we'll send you a link to our YouTube channel where you can see full-length recordings of our webinars, as well as a variety of shorter videos on again, a variety of immigration topics. We will also in that email send you a link where you can sign up for our future webinars. And as well, we will be sending you a link to our website. And on our website, we have a very extensive blog where we post on, again, a variety of immigration topics. So do check those out. We try to put very high quality information out to the public for free. So please do take advantage of that. If you have a question during the presentation, please do use the chat function on Zoom or the Q&A function. We do plan to get through all the questions during the presentation. If the question is particularly relevant to what Kelly's talking about at the time, then I may ask it during the presentation, but either way, I may be saving those questions for the end, and either way, we do plan to get through all of them by the end of the presentation, as I mentioned. And this webinar is being recorded. So again, you'll find after the presentation a link where you can see the recording and a link to our YouTube channel. Without further delay, I will go ahead and pass it off to Kelly.
Thank you, Dustin. Perfect. So we are going to talk about, some employment-based green card options today. We'll be going most deeply into, the EB2 and EB3 categories that are specific to what we call the PERM process, where a U.S. employer will sponsor a foreign national for a green card, but wanted to just briefly touch on the, the full scope of employment-based green cards, just briefly discuss here. So you have the EB1A, this is for individuals of extraordinary ability who have risen to the very top of their field and can demonstrate sustained national or international acclaim and are coming to the U.S. to work, in that area where they have extraordinary ability. We do have particular webinars that are specific to extraordinary ability visas. So if you're interested in that option, I'd encourage you to check that out. There's also the EB1B. This is for outstanding researchers and professors, so it has some requirements specific to that. If you're coming to the U.S. for, a professorship or a research position, in academia. There's EB1C, so this is the multinational manager or executive. So very often people, perhaps who are coming over on an L1A visa as a manager or executive, and they were serving as a manager or executive abroad. Oftentimes this will be the category that they ultimately use to transition, to a green card. Then we get into the EB2 category. So for this, there's kind of 2 options. So one is through the PERM, so company sponsorship, where you have a U.S. employer who's sponsoring the employee. And then the other way is through something called the national interest waiver. So this is where the individual, meets the threshold requirement of having either an advanced degree, so a master's or higher, or exceptional ability in their field. And then as well, they're working on an endeavor of substantial merit and national importance. They themselves have kind of a track record of success or, the ability to advance that proposed endeavor. And then they're able to convince the government that on balance, it's, beneficial to the United States to waive the requirement of the labor certification, meaning the perm. So that's kind of another potential option for the EB2 category. For the EB3, this is for professionals and then skilled and unskilled workers. So these are all categories, based on kind of levels of education or training that are required. So for a professional, it's for a job that requires at least a bachelor's degree or higher. Skilled worker is someone, the job requires at least 2 years of, training or work experience. And then unskilled workers is anything underneath that. And for this category, EB3, this is, again, through the perm process where a U.S. employer is going to sponsor a foreign national for the green card. We're not going to talk about EB4. It's kind of a very specialty category and kind of encompasses many different things like religious workers and other potential categories. So we're not going to touch on that in detail. And then as well, the last one, EB5. So this is, for people who are going to invest and create U.S. jobs. So this, again, we have webinars that are specifically on, EB5 that I would encourage you to check out if this is something you're interested in. Essentially, the investor has to invest either $800,000 in a targeted employment area or $1,050,000 if it's not a targeted employment area, and then ultimately create 10 full-time jobs in the U.S. So there's definitely more nuance to it than that, but those are kind of the overarching requirements if you're interested in the EB5. And those investments can be made through regional centers or direct investments. But again, there's a webinar that specifically covers that. So let's dig a little bit more into the labor certification process, which is also commonly called PERM. So this is the process to get a green card through the EB2 or EB3, categories. It's through the process of company sponsorship. For example, sometimes we may have, E2 clients who are here, on an investor visa running their own business. Maybe their spouse is working, for a company because E2 spouses can work anywhere. They have work authorization that allows them to work anywhere. And then, perhaps that company wants to sponsor the spouse, for a green card. So that's kind of one potential thing that we've, seen similarly with L. If somebody's on an L visa and, an L1B perhaps, and, their company's not sponsoring them, but their spouse has work authorization and can work somewhere else. Sometimes sponsorship can work that way as well. So the PERM is a 3-step process. The first one and the longest one, step of these 3 steps is the actual labor certification, so the actual PERM. So for the PERM process, this involves the U.S. Sponsoring employer has to draft a job description. Whereas in a normal recruitment process, any employer is going to be looking for, great team player, great collaborator, like the absolute best, that you could be looking for. Maybe they include preferred qualifications. When you're doing the PERM process, you have to test the U.S. labor market to see if there's any willing, qualified, and available U.S. workers for the job. And what that means is the government wants the job posting to be as broad as possible to make sure there's really nobody in the U.S. labor market that could do this job. So when you're drafting a job description, you have to only include what are the minimum requirements to do this job in a reasonable manner. So often that does involve kind of discussing with the employer as to what are the actual minimum requirements for this job, as opposed, saying, well, we'd like a master's plus 15 years of experience, but very often, what they would accept is significantly below that. So we kind of need to work that out. Once the job description is finalized, then that gets submitted to the Department of Labor, and they will make a determination on what the prevailing wage is for this type of job. So the prevailing wage is going to depend on the requirements of the job, the duties of the job, the location of the job. So for example, if you're a marketing analyst, in Denver, Colorado, versus if you're a marketing analyst in Wyoming, the wages are going to be different, depending on where the job is located. So once the prevailing wage, is obtained and the employer agrees they're okay with paying that, once the green card is granted, then you go through the actual recruitment process. So this is, also commonly called the labor market test. This is where the employer actually will have to place ads. There's, specific regulations that say where the ads have to be placed, what the ads need to contain. So they need to go through that recruitment process. It's usually at least 60 days, often, closer to 75 days. 30 days where the ads are actively running. And then 30 days, where the employer is continuing to look at resumes, interview anybody who seems qualified, and just conduct that labor market test. If they determine that there are no willing, qualified, and available U.S. workers for the job, they interviewed everyone, nobody was qualified, nobody could learn to do this job, then you can go ahead and submit the labor certification to the Department of Labor. So the PERM is what we call an attestation-based system. So that's where when you submit the labor certification, you're essentially saying, we posted these ads, we followed the rules, but you're not submitting supporting documentation. But sometimes the government will do what we call an audit. So that's where they're going to audit the case. And that's where they say, okay, we do want to see the supporting documentation. Send us proof that you posted these ads, send us the resumes, send us the evaluation sheets. So this can sometimes happen where they take a much closer look at the application. And so it's good to just think about what are some audit triggers, what might cause your application to be audited, because there's a much higher chance of denial if your case is audited, because they're going to be really, really nitpicking and digging into each piece of the application. So certain things, for example, if you require a foreign language, if there's any requirements outside of those normally required for the occupation, so the Department of Labor has an idea of what they think is normal, for any particular occupation. And if the requirements for the job are outside of that, then the company may be asked to justify it. So they may want more information on that. So when you file the labor certification, you are filing it with the U.S. Department of Labor. You're not yet filing it with the immigration authorities. And right now, the process for processing these labor certifications is very backlogged. So we're seeing, almost a year from when you file to when you find out if there's a certification. And if the case is audited, it could take, an additional, 6 or even, 6 months or even more. Once you get to the point where the labor certification has been approved, it's been, certified, that's when you can go ahead and proceed to step 2 of the PERM. So getting through that whole first process, that part is the part that generally takes the longest, given current Department of Labor processing times can even take, over a year, sometimes even over 2 years, just because it's taking a long time to get the prevailing wage and it's taking a long time to get the actual certification back. But once you get to this next step, you can file what's called Form I-140. And with that form, there's going to be a lot less information you have to include. You include details of the job. You include proof that the foreign national meets all the requirements. So if the PERM required a bachelor's degree in a specific field and 5 years of experience, then you would submit, proof of that the applicant had that bachelor's degree and had earned that 5 years of experience, proof through employer letters, things like that. You can also pay an additional fee to premium process the I-140 to get an answer within 15 calendar days. And then at that point, once the I-140 is approved, or sometimes concurrently, if an immigrant visa is available, you can go ahead and file we call Form I-485. So that is the actual green card application, which is step 3 of the process. You can also file through consular processing, and that's something that we'll talk about a little bit later. But generally, the ability to file for the green card or not depends on whether your category is what we call current. So that's where each month the Department of State will issue what's called a visa bulletin that will indicate whether or not there are any available, slots for immigrant visas in the EB2 or EB3 category, or all the other categories as well. Unfortunately, right now, we are seeing backlogs. Both the EB2 and EB3 category are not what we call current. So that means for anybody who's filing, you're generally going to have a wait of, several months or possibly several years, depending on where you were born. There's very significant backlogs for people born in India, and then also some backlogs for people born in China as well. So always good to keep in mind, will you be able to file, even if you get through this whole process, will you be able to file the green card application right away? If not, what plans do you have for maintaining, your underlying status? Also important just to think about family members, so you're going to be able to add your spouse and any unmarried children under 21 to your application. So you want to kind of, with this process, if it's at all possible, build enough time in that, your children can join you before they age out. We can move to the next slide. Perfect. So we're going to dig a little bit more into into step 3 of the perm, which is the green card process step. So there's 2 options here. One is an adjustment of status. So that's where you're in the United States in a valid status, and you file Form I-485 with U.S. Citizenship and Immigration Services. This is usually an option that people will take. Let's say they're here long-term in the U.S., their kids go to school here, their spouse works in the U.S. If that's the case, they have a home in the U.S., very often the I-485 is going to be the best option for them. As I mentioned, the spouse and children, can also file the I-485, and then everyone in the family can file for work and travel authorization as well. So that can be very helpful, particularly if the green card process gets delayed, either the visa numbers retrogress or, just if the application is just taking a long time to be processed. Getting work and travel authorization, even though those applications themselves may take several months to be approved, can give, some good options, while waiting for the green card application. It used to be the case that for employment-based, green cards within the U.S., there wasn't often an interview, but more often, in recent years, they will potentially ask, to have an interview and just kind of confirm the details of the job, and ask other questions before granting the green cards. Another option for getting the green card is through something called consular processing. So what would happen here is, after your I-140 is approved, that approval would be sent to the National Visa Center. They would send an email with instructions for paying an initial fee and then submitting supporting documents. You would fill out what's called a Form DS-260. You would submit supporting biographical documents, birth certificate, marriage certificates, divorce certificates, things like that, to the National Visa Center. They will review to determine, do we have everything we need? And if they do, they'll send your file to the U.S. consulate in the country where you most recently resided. And then that consulate would be responsible for setting up an immigrant visa appointment. You would attend the appointment. If you're approved, you get an immigrant visa in your passport. Usually it's valid for 6 months. So during that 6-month validity, you have to enter the United States, and then your green card is mailed to you, a couple months after you enter the United States. So this option, let's say that somebody was in the U.S., but their underlying status lapsed and they didn't have any options to stay in the U.S. So they went abroad, but the company was still interested in working with them. Then the process could certainly continue, and the person could get their green card abroad. Additionally, if someone is living in the U.S., but they need to travel constantly, and maybe they're not here on an H-1B or an L, which is, the exceptions that allow travel after you filed a green card application. So if let's say somebody is an E2 investor and they need to travel constantly for work, in that case, they may need to do consular processing because they wouldn't be able to, travel on the E2 after the green card application, the I-485 is filed. And, waiting for the travel authorization, that in itself can take several months. So for some people, depending on their needs, the consular process may be better. So another very common question we receive is who can pay for green card fees, and it's relatively clear, and it is a very important thing to consider. So for the perm process, the sponsoring employer has to pay for these fees. The government is very sensitive to the idea of an applicant coming and essentially paying an employer to, get their application through. And it is actually a question that they ask on the perm labor certification, which is, has the sponsoring employer received any payment for the submission? So that's not permitted. All the fees related to the perm process. For example, when the company posts advertisements, generally there's some fees associated with that. The company has to pay for all of that. However, once you get to the I-140 petition and the green card petition, there's much more flexibility. Either the employer or employee can pay for those fees. And then clearly, when it comes to dependents, again, either the employer or employee can pay for those fees. So no flexibility really with perm fees, but with, I-140 and green card fees, if there's, a bit more flexibility.
Perfect. Thank you, Kelly. And I am going to speak a bit about the topic of dual intent, which Kelly has already touched on a bit when she was talking about the difference between adjusting status from within the United States versus consular processing outside the US at a consulate. But I think the best place to start when talking about dual intent is the fact that under US immigration law, the government always has the assumption that a foreign national who is seeking to enter the US plans to stay in the US, and that it is the burden of that foreign national who's seeking entry to convince the government official that they do not plan to permanently stay in the US. Unless they have an immigrant visa and they've actually applied to permanently stay in the US. But if you are trying to enter the US on, say, a B1 visa, a B2 visa, which are temporary visitor visas, and the government believes you plan to stay permanently, you'll be denied entry. So that is just the framework for US immigration law, for better or for worse. It is something, though, that people who are planning to navigate this process from a non-immigrant visa, like an E2, to a green card, like, say, an EB2 or an EB5, they do need to navigate this kind of hurdle. So basically, most non-immigrant visas do not allow dual intent. Dual intent is limited to certain very few non-immigrant visas, such as the H-1B, the L visa, the O visa. And basically, dual intent allows a person to enter the US on a non-immigrant visa, even though they have the intention to stay, which means that essentially they have a pending green card application. Now, as Kelly said, the timing is very key here. So what actually does indicate that you do have the intention to stay, and what is the relevant point at which this intention is relevant? So let's say you want to enter the US on a B2 visitor visa, and maybe someday it might be nice to have a green card. That's not really what the risk is. The risk is where you are seeking entry on a non-immigrant visa, and on that visit, you plan to actually pursue a green card. That's what is problematic. Or if you're already in the US and you're trying to extend your non-immigrant status, let's say you're trying to extend your E2 status, and right after you file that extension application, you plan to file an adjustment of status application to an EB2. That's what would be problematic. But having a general goal of someday applying for a green card, or even having a pending application at a consulate, as Kelly was suggesting on her slide, isn't necessarily problematic. But the real takeaways here, I know that there's a lot of information I'm sharing. I think the real takeaway is, if you're in the US on a visa that does not allow dual intent, so that would be an E2, an E1, a TN, you need to be very careful about when you are filing your green card application. And by green card application, I do mean the I-130, the I-140, even those early stages. If you want to be safe, oftentimes waiting until you've renewed your underlying non-immigrant status, so whether that's E2 or TN, renewing that so that you have a few years left on that, could be wise before you file the application for the green card. Or choosing consular processing, as Kelly was saying, By choosing consular processing, you might actually mitigate the risk that when you are entering and exiting the US in your TN status or your E2 status, you're able to explain that your intention is not to adjust status on that visit, that you have a pending application that will be processed at a consulate requiring you to leave. Therefore, you cannot have the intention to adjust status on that visit since you have to leave. But if another method that we sometimes recommend to clients if they do want to mitigate this risk is to change their status from a TN or an E1 and E2, which does not allow dual intent, to a visa that does, such as an H-1B, an L, or an O visa. And by doing that, you can feel much more free to have that pending green card application. So Kelly, I'll pass it off to you to talk about considerations when moving from a visa to a green card.
Perfect, perfect. So yeah, so it's something, I think, Dustin, you were just flagging in terms of, maybe wanting to change your status to a status that's more friendly for the green card process, like an H-1B. But it's not required to do that. Certainly, there are people who are on a TN and they transition directly to a green card because it can be very difficult sometimes to get onto H-1B or another status may not be available. So you just want to think about if the goal is to move seamlessly from, your non-immigrant status in the U.S. to the green card, you want to consider how much time is left on your underlying visa. Will you be able to renew it? TNs could be renewed in increments of 3 years. But generally, like you don't want to be in a situation where you're coming up on the end of your 3 years on your TN and your I-140 has just been filed, and now you need to go back and get a new TN, TN visa, either at the border or at a consulate. Once the I-140 is filed, even though it is a petition that's generally, if it's being filed through the PERM, it's filed by your employer, they certainly could, view this as being an indication of immigrant intent. And even though, as Dustin mentioned, generally intent should be assessed at each entry. So even if you have an approved I-140, if you're able to say, well, I don't intend to adjust status on this entry, technically you should still be permitted in. There's many officers that, will not necessarily accept that explanation. And if they do have that discretion where if they feel that the person, has permanent intent and the visa requires, non-immigrant intent, the intent to return to their home country, they may not be willing to renew it. So could be, much harder to renew any visa that has a very high standard for, proving non-immigrant intent. So visas like the F1, the TN, the B visas, those are ones to consider. The standard for, kind of E, E1, E2, E3, and O's, it's a little bit more, almost like we call a quasi dual intent visa. So it's not full dual intent the way that an H-1B or an L is, but they generally are, less strict on this particular requirement. For example, for the E1 and E2, you're permitted to move your whole residence to the U.S. So sometimes the standard can be a bit less for those. So even if you have an I-140, filed, particularly if your priority date is, if your priority date is, is long dated, so it's going to be many years before you can apply for your green card, then, that could be, something that is, an argument that you make as to why you don't have immigrant intent. So another thing to consider, do you want to adjust status in the U.S.? Do you want to get your green card through consular processing? So that, goes back to a lot of what I was talking about earlier. In terms of, do you want to just stay in the US and have your spouse and children all file your I-485s at the same time? Or do you want to, get this green card through consular processing? So another thing to consider is, family. So how old are your children? Do you want your children to have green cards? Like, are they here on a non-immigrant dependent visa and they need another option? In that sense, it can be really good to file early to avoid issues with your children aging out, which they would do either, when they got, when they're married, if they're married before 21 or when they turn 21. Perfect. So let's talk about some green card interview considerations. So it's more and more, it's the case that we're not seeing nearly as many interviews for green cards, for employment-based green card petitions. But, previously, We did start to see a huge uptick in this. So it is always really important. You don't want to assume that you're not going to have an interview. You want to assume you are going to have an interview and be prepared for it. So prior to your interview, you want to review your immigrant visa petition. So that means your I-140 petition, and then also your green card petition. So the I-485, or if you did consular processing, all the documents you submitted to the National Visa Center. You want to print and bring all the documents they request to the interview. There'll be instructions on your interview notice. So you want to follow those, to the letter, really, review everything and bring copies of everything. Bring also originals and then copies of the originals in case they want to keep them. So things like birth certificates, marriage certificates. For your medical exam, if you're in the United States, make sure that you have an I-693 form that hasn't expired. So now it's over, it's 2 years for them to expire. So most of the time they wouldn't be, but just keep an eye on that. If you're going to the consulate, then the medical exam is done abroad with, a panel physician who is, designated by the Department of State. So you should, check the consulate, instructions for that, as I'll generally have very specific instructions on how to make that appointment, that medical appointment. You want to give yourself enough time to make sure that, if there's any, vaccines that are needed or, any issues at the medical exam, that they can be sorted out before your interview. You also want to get updated proof of your employment from your sponsoring employer. So, if they did request what's called a supplement J on your I-485, you can bring that. Otherwise, you can potentially bring in, a job offer letter. If you're currently working for the employer in that same role, you can bring pay stubs. So anything to demonstrate that kind of the terms of the employment that were outlined in the, perm application are going to be are either being complied with if you currently hold the role, or will be complied with once the green card is granted. Also proof of maintenance of status if you're in the United States. So, if you're doing an adjustment of status, one thing they want to see is that you have not ever violated your status in the past. So no overstays, no time out of status, no unlawful presence. If you have had any of those violations, you can potentially still qualify under a provision called INA 245K, but definitely important to discuss, with your attorney if you have any of those, previous status violations, so they can make sure that the forms, outline how you are eligible under this exception. Always a good idea to meet with your attorney and do a practice interview. Even if you feel very comfortable, when you go to the interview, sometimes people will get nervous. And you want to just, have some practice answering the questions, because when you go to these interviews, you want to be honest and you want to be forthright, but you also don't want to, get nervous and speak for so long that you raise other questions for the officer. So it can be very helpful to have that conversation with an attorney ahead of time to make sure you're prepared for the interview. Perfect. So what is porting? Especially because this green card process is so long, there's a very common question is, at what point would, an applicant have the ability to leave their employer and go to a new employer? And so, for most of the time, like for the, let's say that you have a company and it started a perm labor certification for you. And then while that's ongoing, it's taken a year, but while that's ongoing, you get a new job and you switch your H-1B to the new job. So at that point, the fact that a labor certification was started for you, you really don't take any benefit from it. And then similarly, even if you get to the I-140 stage, the benefit that you get basically is being able to retain the I-140 priority date. And then assuming the I-140 is not, withdrawn within a certain period of time, if you're on an H-1B, you can use that approval to get further H-1B extensions if your category is backlogged. But really, until you are at this stage where the I-485 has been pending for at least 180 days, once you get to that stage, that's when it becomes much more flexible. So prior to that, really, leaving the employer will put you in a position of almost having to start all over again, just with some, minor benefits like keeping your priority date, which, is a good benefit, but doesn't put you, back on the green card track yet. But once you get to that stage, your I-485 has, your I-140 is either approvable or has been approved. Your I-485 is pending for at least 180 days. At that point, you could what they call port. So that's where you would go. You could go to a new employer as long as your new employment is within the same or a similar occupational classification as the job offered in the perm. And when you do it at this stage, then the real benefit for the new employer is they don't actually have to go through the perm labor certification process because of how late you are in the process. As long as they can demonstrate that the job is the same or similar occupational classification, you can still move forward. So things they'll look at, job duties, job title, salary, what training is required. Are there any certificates required? So definitely, you want to kind of look at the jobs and match them, as much as possible before, undertaking kind of the porting, just to make sure that they'll accept it. And you'll be able to proceed with your green card through this new employment. Perfect. So, and then another, very common question again, because people are in this process for years and years, they don't have much flexibility necessarily if the employer is driving the process. And so they do want to know, can I change my employer after I get my green card? Am I still tied to this employer? So when you get your employment-based green card, when you file the forms with the government, when you go to your interview and you make attestations, you are saying in good faith that you plan to continue working in this role and a permanent role in the US. That being said, there is nothing that prevents you, like the day after getting your green card, from leaving your employer. It's not based on you needing to stay with the employer. The concern, though, is that let's say that you get, in the future, you want to file to become a U.S. citizen, or there's some other benefit that you want to get, where the government's going to be looking at your history again. You want to make sure that there's nothing that, would flag for them. Well, we think maybe this person got their green card through a misrepresentation. They quit their job the very next day. Unless there was kind of a real reason, or like, the employer was going to transfer the person out of state, whatever the reason was, you want to just make sure that if you have left the employer, very quickly after you're getting your green card, that there's an explanation for that, such that they don't believe that you were misrepresenting yourself, when you filed the paperwork or went to the interview and said you planned to work for this particular employer. So definitely good things to keep in mind. There's no rule for how long you need to stay with the employer, but a time period of several months at least is usually, a good time frame to think about before you would reasonably say, okay, I've looked for something new and now I'd like to, to leave this employer.
Perfect. Thank you very much, Kelly. So we do have a number of questions. They fall into a few categories. I think one category that a few questions have fallen into is regarding the EB-2 National Interest Waiver, which has become one of the more popular options for our clients who are on an E2 visa to pursue a green card. So the first thing I'll say is that we have several full-length EB2 NIW webinars, both coming up and recorded on our YouTube channel. So please do check those out. We go into much, much more detail on the EB2 NIW. But Kelly, do you just want to give a very high-level view of the EB2 NIW, since a number of people are asking about it?
Sure. Yeah, absolutely. Would definitely echo, check out like our EB2 NIW, presentation where we do go into significant detail in terms of the requirements for the EB2 NIW. It is a very attractive option because it does allow for self-petitioning. To qualify, you need to meet a threshold requirement of either having an advanced U.S. degree, so that's a U.S. master's or higher or equivalent, or exceptional ability in your field. And exceptional ability is it's a lower standard than extraordinary ability, but still substantially above what's ordinarily encountered within the field. And you prove that by showing you meet 3 out of 7 different criteria that relate to things that would show you're, somebody who has exceptional ability in your field, like letters documenting 10 years of full-time experience, things like that. So once you've met that threshold requirement, the next piece is the national interest waiver piece. And so there's 3 criteria to that. So one is you have to be focused on an endeavor that has substantial merit and national importance. So they're going to look at, what are you actually doing in the US? Does this have substantial merit and national importance? And then are you yourself as the applicant well positioned to advance this endeavor? So if you let's say you work for a company that's doing really good work and you are an accountant in that company, even though what the company is doing may arguably have substantial merit and national importance, it's not your endeavor that you're furthering. So there does have to be, usually the person who's working on this they have their own endeavor, their own project they're working on, or if they're working on it in the context of a company, they are kind of a very senior or critical person working on that endeavor. Because you need to demonstrate, that the individual themselves, has a very high profile, can be considered an industry expert or has a track record of success in this type of, this type of industry. We have many E2 investors who perhaps are, with their companies doing kind of new, novel, groundbreaking work, or, getting patents, or, doing kind of industry changing standards. Those are the types of things, the endeavors that would rise to the level for the national interest waiver. And then the final requirement for national interest waiver is just that on balance, it's beneficial to the United States to waive the requirement of the labor certification. So for entrepreneurs, they can easily argue the labor certification process doesn't work for me. It's not set up for entrepreneurs. So that can be a reason, to meet that third prong. Sometimes also if the work the person is doing is sufficiently urgent, or the person themselves is so accomplished that even if other people in the US were doing it, the US would still benefit from this person doing it. That's another potential argument. So that's kind of the basic outline for the EB2 NIW, really heavily focused on both the endeavor and the person's background. So I would definitely, if you're interested in that, encourage you to look at our other resources.
Absolutely. And for entrepreneurs, those who are not going to be sponsored by a third party employer, the EB2 NIW is a great option. The EB1 is a great option. And again, we do have webinars on those. A few questions came in that I can quickly address that touch on the topic of dual intent that I had presented. One question is, I've switched from a J1 to H1B in June 2023, so over 6 months ago. Is that too soon to start an NIW green card application? In general, I would say 6 months is probably fine. But I think what's more fundamental is your intention at the time that you apply for the benefit. So what the prohibition is you cannot apply for an entry on in a non-immigrant status, or to extend or change to a non-immigrant status if your intention is to apply for the green card. So that's the most fundamental thing, is if you're going to apply for a green card, after you do that change, and that, I think that's what the government's getting at. And then there are indicators that they look for. And one indicator is the amount of time you've waited before you file the green card application. So 6 months as a single indicator is probably fine. But do be careful if your intention at the time you changed was in fact to pursue the green card. Though I think it is perfectly fine if your mind did change. That's perfectly fine, and by and large, we don't see that as a problem. Let's see. There are also an EB5 question. So we have, again, extensive webinars, an hour plus long webinars on the EB5. It is a very complex green card. This is the investor green card. More specifically and technically correct is to call it the job creation green card, because you do need to create at least 10 jobs for US workers if you're going to apply for an EB5. The question is, can I gift funds to more than one person who would then pursue an EB5? There's no prohibition from doing that. Each of those people would apply for their own EB5 green card, and each of them would need to show exactly where they got the money from. So if you're going to give funds for an EB5, make sure you have very clear documentation. But on the face of it, there is no problem with gifting more than one person, the investment amount. And yes, that could be a way to find a faster pathway to a green card than a family-based green card application. You would need to look at what Kelly mentioned before, the visa bulletin, which is released by the government every month, and that will tell you how long you would have to wait in each category of a green card, whether that's employment-based 1, 2, 3, 4, 5, or a family-based category. So do check that out. I would say if you're curious about the EB5, a consultation is probably a good idea, just because it is so complicated and there are a number of places where you can get tripped up on the EB5. Kelly, there are a couple questions that talk about the cost and the time frame for applying for an employment-based green card. Generally speaking, it's a good idea to set up a consultation, and we can give you specific information on the legal fees and the filing fees for whatever option's the best for you, as well as the time frame. So do schedule a consultation if you are serious about considering one of these paths. However, Kelly, can you just give just a very general sense in terms of how long the process takes for the questions about an EB3 and the perm process generally, as well as just a ballpark range for cost?
Yeah, so I'm happy to talk through the processing times. But I think for the EB3 and the EB2, unfortunately, they are taking a long time right now. So probably, several, 2 to 3 years. Just again, because the prevailing wages themselves are taking 10 to 12 months and labor certification is taking 12 months. And then you need, so that in itself is just 2 years. And then you actually need the time to test the labor market. You need the time for the company to get things together. And then as well to actually have the green card in hand, maybe you're waiting another year just for the immigrant visa to become available. And then there's the processing time for that. So generally you're looking at a time frame of, 2.5 to maybe even up to 5 years, much longer if you're unfortunately in a category with long backlogs like India or China. So definitely something to keep in mind. I think, as Dustin mentioned, happy to provide, information on fees through engagement letters. If you're interested in that, please reach out to us. We're happy to send the engagement letters that go over kind of the ballpark fees. And then as mentioned previously, the employer is responsible and does have to pay for, all the perm fees. So that's, definitely something, if you're discussing with your employer, they need to be willing to do that to go over the, the perm process.
Perfect. There are a couple questions. One is about the H-1B. So that's outside the scope of this presentation. We have a lot of information on our blog about the H-1B and the steps to apply. And I believe we also have webinars that touch on the H-1B. So I would point you in that direction. Schedule a consultation if you want to talk about the H-1B in more detail. Now, also a question that is more probably better suited to a consultation. So again, if you want to talk about the details of your situation, schedule a consultation. We don't want to talk about that during the webinar. Kelly, I am abroad. I assume this person has a B1, B2 visa. They are abroad. I assume the visa is going to expire pretty soon. They want a consular process for an EB2 though. Should they renew the B1, B2 visa first? There's really no reason not to, I imagine, but do you want to talk about that?
Sure. Yeah. So I think, I would say definitely try to renew the B1, B2 first, like assume, if you have a 10-year B1, B2 and there's 5 years left on it, then no, don't renew it. But assuming it expires very soon, there's a benefit to renewing it before you file your I-140 because on the DS-160 application, there's a question that says, have you ever filed an immigrant petition or has anyone filed an immigrant petition for you? And if you do that, you're going to get questions, what are your plans? What are your future plans? So I think better generally to file for the B1, B2 and then, plan the I-140 filing for afterwards.
Perfect. And then a question about perm. If the employer, if the applicant has been working for an employer, does that help with the perm process at all? Does it make it faster or easier in any way?
It doesn't. So unfortunately, like the fact that he is or the spouse is already working for the company, that's just on the basis of having, the work authorization through the E2. It doesn't kind of make the perm process any faster or quicker. In fact, it's also sometimes can be, depending on whether the person had, work experience prior to joining the employer, sometimes, it can be a little problematic just because it's very difficult to use any experience gained with the sponsoring employer as part of your perm process. So unfortunately, no, it doesn't kind of give you any fast track through the perm. But, like the perm process would proceed the way we described in the webinar.
Perfect. Well, thank you very much, Kelly, for sharing your expertise. And to our participants, thank you for the great questions. Do keep an eye out for that email. Check out our YouTube channel. Reach out to us if we can be helpful, particularly through a consultation. We're always happy to speak. And keep an eye out for future webinars. We hope to see you there. Stay well, stay safe, and have a great day in the meantime. Thank you.
Thank you.